Proceedings Act 1947, Crown privilege only provided avenue for the Crown to apply for suppression of evidence on the basis that disclosure is against public interest. Now replaced, public interest immunity, which is short for PII, enables any party or witness in any proceeding to apply for non-disclosure. This is recognized in Section 28, subsection 1 of the Crown Proceedings Act 1947, which implies that if the Crown is a party, it may be required to produce documents for inspection and to answer any interrogatories. This process works as such, where once a claim of PII is made, English courts as an independent body will weigh the interests of justice against the reasons for the claim of immunity. In majority of the cases, if the court decides that public interest will not be prejudiced by disclosure, production of the documents will be ordered for inspection. This was evident in the case of Conway and Rimmer, where despite the existence of a minister's objection on grounds of public interest to the production of evidence in legal proceedings, the court would determine independently whether evidence for which privilege had been claimed should be withheld. Once it assessed the detriment that might accrue to the public interest given disclosure, it was held that the documents, in this case, were to be reproduced, considering the magnitude of importance it had to the civil case outweighed the little harm that came from production. Sweden case laws were rather groundbreaking in the establishment of PII, as seen in the case of R and Chief Constable of West Midlands ex parte Wyoming, where the House of Lords held that a minister could discharge their duty by creating their own judgment of where they think the public interest may lie, and thus was not obliged to claim PII in all cases where it may be applicable. While it can be seen that courts are fully equipped to reconcile the apparent conflicting demands of national security and human rights, however, concerns regarding PII was prevalent in the Arms to Iraq affair, where PII certificates that were obtained by the British government were suppressed, critical information of the courts of national security were quickly overturned, forcing the documents to be handed over to the defense. As a result, scrutiny looms over and means of reforms commence with the production of the Scott Report. Given that suppression of evidence results in potential injustice to particular litigants, it seems equitable that the law should permit suppression only when the public interest in that suppression of the evidence undoubtedly outweighs the public interest in the due administration of justice, and not within ambiguous areas where complacency and convenience are favored.
Hi, I'll be talking to you about concerns that are related to public interest immunity. I'm going to talk about two concerns. The first is with regards to how public interest immunity potentially allows for governments to conceal procedural improprieties committed on their behalf or by public authorities. The next, I will talk about how public interest immunity potentially helps protect the privacy of very vulnerable groups of individuals. But I will also talk about the converse, how public interest immunity is potentially used to harm very vulnerable groups of individuals. Let's start with the first concern, which is about procedural improprieties. Now, in status quo, governments are the sole arbitrators in deciding what information is damaging to national security and what isn't. The reason as to why this is true is because governments tend to work in tandem with security agencies, with intelligence agencies, so they are sort of assumed to have the most power in this particular area. Now, the problem with this is that we don't exactly know what type of information may be declared as damaging to public security, because governments are the ones coming up with that decision. More often than not, we think public interest immunity is a potential avenue for governments to conceal information that is potentially damaging to them. Now, let's use a case to highlight this concern. The case that we're going to talk about is the case of Harry Lambers v. the St. Albans Crown Court in 2018. Now, this case involved the usage of redacted warrants. So an individual had their home raided by police, and when asked as to why the raid was occurring, they were given a redacted version of a report or a warrant. Now, the reason why this is highly concerning is for a couple of reasons. Firstly, that person doesn't know what type of warrant they were receiving, meaning they don't know and they cannot check if proper procedure was followed in attaining that warrant. But the second thing, the warrant also did not disclose reasons as to why that individual's home was being raided. So that person had no ability to figure out, firstly, what type of warrant was being given to them, but secondly, why their home was being raided in the first place. Now, this is obviously quite concerning. So the person involved in this case decided to lodge an appeal, but it was unanimously dismissed by the court for the reason being that the redacted material was protected under public interest immunity. Now, this is highly concerning. We don't know how the warrant was attained. We don't know what the redacted material could have suggested. This just means that the person firstly cannot have a check and balance on the government or the police in this particular situation. But secondly, there is also very minimal ability for this person to attain information that could have potentially really helped with the appeal. So that's the conclusion for the first concern, which is that it could be used as an avenue to conceal procedural improprieties on behalf of the government. Let's talk about the second concern, which is about vulnerable individuals. So more often than not, sometimes governments are involved in proceedings that involve very vulnerable groups of people. These are people who are mentally ill. These are people who are children. These are people who have potentially been sexually assaulted. For this very vulnerable group of people, seeing as they are in a very tight and very tense situation, their privacy is of the utmost importance to them. A research paper from the University of Toronto suggested that the reason why a lot of victims of sexual assault do not report or go to court is because they are afraid of information relating to their suffering being publicized to the public. So when public interest immunity is used to help assuage these people's fear and their concern for privacy, we think that it leads to many benefits of individuals just being more comfortable in courts and also more people reporting. A case that can be used to highlight this particular concern is the case of X, Y, and Z in 2016, which was a case involving a third party trying to attain information regarding the trial that involved a couple of children. At the end of the day, the court decided that the public cannot attain information with regards to this case. The only people that should have access to this information are people like the police and security forces. So public interest immunity, while it is used to conceal information, sometimes the information that is being concealed is very important because the converse is publicizing very, very damaging material that could potentially hurt an individual's privacy. While this all sounds well and good, the converse also applies when individuals want to publish information, but governments don't allow them to do so. Now, a case that can be used to highlight this is the case of the Attorney General and the Guardian newspapers that occurred in 1996. This was the Spycatcher case that involved a former individual within the service intelligence that tried to restrict them from publicizing information that was critical of government procedures. Now, while the court in Australia did dismiss the United Kingdom's claim in this particular context, it's important to note that it was only dismissed on a technicality, which was that a foreign government was trying to restrict the implementation or the release of information in a foreign country. If this happened in the United Kingdom, we question whether or not we would have actually gained access to all the horrible things that Secret Service or intelligence individuals were committing because it could have potentially been covered under the guise of public interest immunity. Therefore, there are many concerns that are related to public interest immunity, and we hope this was more updated.
There is an appreciated contention in the development of common law between established principles of discovery and disclosure and public interest as Lord Clark has described for the principles of PII in Alvarez's case. The intended desire, as Tompkins mentioned, is to pursue equilibrium between them. However, Forsyth questioned who could be the credible party to find that balance in the conundrum to reconcile justice and public interest, as it seemed both issues cannot be compromised. Yet, there is a conspicuous transformation in the framework and application of public interest immunity outlined by the courts, where the courts took a wild farce in the application of public interest immunity whilst dispensing justice. Previously, Sir William Wade wrote that the Crown was conferred the legal authority to override the rights of the litigants not only in circumstances where it was imperative to divulge information to the courts, but also in situations where it relied on the permission of governmental departments. However, a major development of public interest immunity was observed in Conway and Rimmel, in which the House of Lords reversed the decision in Duncan and Campbell Larry. The courts felt that the disclosure of the evidence was necessary in the interest of the litigants in Conway's case, and has established that the courts have the final say and not the Crown where the public interest immunity has succeeded. Not only that, the surprising attitude displayed by the courts was the fruition of the advocacy and the change in environment, especially the influential emergence of Article 6, Fair Trial, stipulated in the European Convention of Human Rights. The justification to this transformation was harmonious to the case in Scotland 12 years prior, the case of Glasgow Corporation and Central Land Board 1956, where the Scottish courts could circumvent where the private interest outbalanced the public interest in order to achieve impartiality in administering justice. There should be the right for the parties to litigation for all admissible evidence relevant to their claims presented before the courts. Further, the courts attempt to balance the need to achieve fairness, injustice, and public interest. This is because public interest immunity ought not to be perceived as a body of law that is wholly sui generis. The court took an assertive stance in possessing the decisive authority whilst considering the administration of justice, whether the public interest immunity is feasible and fair in restraining disclosure. This is due to the fact that preventing the courts from governing the admissibility of the evidence into the legal proceeding and having the comprehensive analysis of the validity of the PII will run in contrary to the principles of the rule of law, contradicting A.V. Dicey's third postulate, where our rights ought to be protected by the law, and was parallel to the case of Rogers and Secretary of State of the Home Department. The decision in Ex parte really echoed the antecedent sentiments in Matrix Churchill, where the accused was acquitted after the administering claims of public interest immunity was abandoned and was deemed as an isolated crime in the wilderness. It seems that the courts are poised to develop the application of PII.
The PII claims are usually valid when the minister determines that certain documents in question are subject to such claims. Though this occurs when the contents of said documents fall into a specific class. So when this occurs, the minister is said to be under a duty to make a PII claim, as said by Lord Bingham in the case of Makanjuola and Metropolitan Police Commissioner. So usually a public interest immunity claim cannot be waived. However, an exception to this rule would be when those directly involved with the reception of the information concerned give their consent for it to be disclosed. Bingham further iterates this point in the Air Canada case, where a group of airlines claimed that there was an unlawful increase of landing fees by the British Airports Authority. So the minister in question disclosed only some documents. He claimed PII for the others. So the House of Lords actually allowed this and held that when the Crown or government claims PII, it's discharging a duty, not claiming a privilege. So in the case of R against H and C, Lord Bingham sets out the distinction between what should and should not be disclosed. So basically, if the material does nothing to weaken or strengthen the case of the prosecution or the defendant, there is no need for it to be disclosed. Any unspecified and general allegation should not be reason to disclose sensitive materials. So it's also the minister's duty to delineate and identify the class of documents before he is able to claim privilege. So under the Criminal Procedure and Investigations Act 1996, a non-exhaustive list of the type of sensitive material that could be claimed under PII for its non-disclosure would be affairs pertaining to national security or state affairs, journalist sources, criminal investigation, detection or prevention of and information including young children. So when a non-governmental party possesses any document which the courts have deemed applicable under class immunity, the court may interfere to prevent its disclosure. However, if the Attorney General or an appropriate minister endorses the party's decision to disclose said document, the court will usually act upon their views. One justification for supporting a PII claim is the candor argument, where the disclosure of reports may discourage others from being fully honest when making similar reports in the future. However, this candor argument has found much criticism recently. A major criticism to this point is that any report or statement filed against an officer is made in the knowledge, basically, that such information could be used as evidence in the first place. So a witness who makes a statement under such circumstances should expect the possibility of having the information being used as evidence in the courts. So the use of PII claims thus diminishes here, in this sense, the integrity of security services.
In 1992 followed the collapse of the Major Churchill case, which involved the unauthorized export of arms by a Coventry-based firm, Major Churchill, to Saddam Hussein's Iraq. This was said to be in breach of export controls and a report was filed. However, several documents could not be disclosed after government ministers signed PII certificates, which were later rejected by the judges, and thus the trial collapsed. An inquiry was set up by the Prime Minister under Sir Richard Scott for the purpose of investigating this issue. The Scott report studied individual ministerial responsibility to the Parliament and eventually uncovered a series of injustices conducted by public authorities in criminal prosecutions. Despite the efforts made by Sir Scott in diminishing miscarriages of justice brought about under the pretext of class claims, there arose several criticisms with reference to the technique applied in the Scott report. Authors Ian Leigh and Lawrence Lusgarten claimed that Scott report failed to correctly diagnose the disease or to apply the necessary cure, a sentiment that echoed through the United Kingdom over the years. Senior Tories criticized Sir Scott for using a technique that was unjust to witnesses, since the report emphasizes heavily on doing most of the inquiry through paperwork with minimal involvement of witness questioning. The Scott report's method of limiting witness cross-examination through accurate unfair comes at the price of speed and, according to Lord Howe, accountability. Howe iterates that Scott's method denied the witnesses their right to be informed of any allegations claimed against them, as well as their ability to consult with a lawyer before being put on inquiry. Another failure on the report would be that it does not discuss the legal and institutional means by which governments should be obligated to disclose any information before the Parliament. This further begs the question that should have been analysed. Does an accountability to the Parliament suffice in the United Kingdom's democracy? Or does accountability also encompass the citizens' right to bring their rulers into account through the representative they elected? Despite its faults, the Scott report still makes a valid stand in the fight against miscarriages of justice in class claims. For instance, investigations in a case are limited to only involve factual matters. However, these factual findings are not necessarily free from political controversy. Inquiries may be set up, but the government may still reject the inquiry's findings, as proven when Scott uncovered that the Parliament was misled when the Howe guidelines were altered. In this case, judicial neutrality is useful in depoliticizing a controversial matter. Another contentious concern involves the doctrine of separation of powers. The Parliament, from experience, is incapable of being independent enough to investigate the ministers' misconduct in their ministerial positions. The real challenge here is whether said investigations are best carried out by the judiciary or by another establishment. Still, it can be asserted for now that the judiciary is capable of passing impartial judgment in such cases. Furthermore, the Scott report does not stand alone as the only inquiry set up to look into issues pertaining to class claims. For example, there are the Salmon Commission, the Franks Review, and the Norm Committee. The existence of various inquiries in order to tackle the continuing concerns related to class claims show that different models with their unique methods suit different purposes. And the Scott report still serves as an efficient study of public interest immunity claims.
In conclusion, without a doubt, illegality threatens the principle of PII. However, numerous credible individuals have strived to create precedent in regards to when PPI is warranted and otherwise. This is reflected by the statement by the Lord Chancellor Lord Kilmer in the year 1956, where he drew a distinction between documents which were absolutely necessary to protect the public functioning of civil service and the documents which are relevant to litigation but do not require the utmost degree of confidentiality to ensure protection of public interests. Though we have come a long way since then, given that the aftermath of the Scott's report, which prompted the government to ensure abuses of PPI come to a halt, followed by appropriate reforms. Then the question becomes, will the plethora of case laws that have set precedents to how courts have functioned in the past decades now change? Will they now be put under a microscope with additional mechanistic structures that attempt to be check and balances to how PPI has been functioning in the future? It seems that we are now left with more query now than ever before, though we must recognize that the evolution of PPI is at the brim as we speak. Nevertheless, we can be certain that the principle of PI must exist for a couple of reasons. The first, that it serves as a necessary platform whenever there are concerns that national security or public interests are at stake. The second, the protection of vulnerable individuals that requires sensitive information to be kept from the public. Taking into account that these reasons are ones that we cannot do without, it is expected that the PII will continue to exist. Though, we must look forward to the evolution that allows PPI to exist in the purest, most effective form that can serve in its intended purpose.
Going down to surprise the guys.
And you're gonna get a heart attack there.
Oh no!
We're here.
Yeah, so this is our.
I was like, I want to say, are you getting fatter? Pretend to listen to me, oh my gosh.
I'm listening.
Yeah. Just sad. Yeah.
Start. 2, 3, and die.
What the?